This video is part of a series based on the book Impact or Invisible: Surviving the Data Age with AI by Angel Reyes, available on Amazon. Welcome to video 25 in our AI.powered research series. Today we're covering something that's about to affect researchers worldwide, the European Union AI Act. This is the world's first comprehensive AI regulation, and even if you're not based in Europe, it's likely to impact your research and publications. Here's why this matters to researchers. The EU AI Act establishes rules about transparency, labeling, and documentation for AI systems. Some of these rules apply to AI.generated content, which means your use of AI in research may need to comply with these requirements. Journals with European publishers, collaborations with European institutions, and research involving European participants may all trigger compliance obligations. Many researchers I talk to have heard about the AI Act but find it confusing. It's 400-plus pages of legal text with numerous provisions, exemptions, and implementation timelines. You don't need to read all of that. What you need is a clear understanding of the key provisions that affect research. That's what this video provides. By the end, you'll know what the AI Act requires, whether it applies to your work, and how to ensure compliance. Let's understand what the EU AI Act actually is and why it was created. The EU AI Act is a regulatory framework that categorizes AI systems by risk level and imposes requirements accordingly. It was developed over several years in response to concerns about AI safety, transparency, and fundamental rights. The Act identifies 4 risk categories. Unacceptable risk includes AI systems that are banned entirely, such as social scoring systems or real-time facial recognition in public spaces. High risk includes AI used in critical areas like healthcare, education, and employment, which face strict requirements. Limited risk includes AI systems that interact with people, which must meet transparency requirements. Minimal risk includes most AI applications, which face no specific requirements. For researchers, the most relevant provisions fall under limited risk, particularly Article 50, which addresses transparency obligations. This article requires that AI.generated content be labeled or disclosed in certain circumstances. The Act entered into force in August 2024, with different provisions taking effect over a staggered timeline. Some requirements are already active, others will come into force over the next 2 years. Understanding where your AI use falls in this framework is essential for compliance. Let's focus on Article 50, the provision most relevant to researchers using AI tools. Article 50 establishes transparency obligations for certain AI systems. The key requirements include: first, AI systems designed to interact directly with people must be designed so that individuals know they are interacting with AI rather than a human. This applies to chatbots, AI assistants, and similar tools. Second, content that constitutes deepfakes, meaning AI.generated or manipulated images, audio, or video that depict existing persons doing or saying things they didn't do, must be disclosed as artificially generated. Third, AI.generated text that is published for the purpose of informing the public about matters of public interest must be labeled as AI.generated. This third requirement is the one most relevant to research. If your AI.generated content could be considered informing the public about matters of public interest, and academic publishing often fits this description, you may need to disclose the AI generation. The good news is that the transparency requirements align well with the disclosure practices many journals already require. If you're already following journal AI disclosure guidelines, you're likely in compliance with Article 50. Here's a compliance checklist for researchers using AI tools under the EU AI Act. Step 1. Determine if your AI use produces content covered by Article 50. If you're using AI to generate text that will be published, especially in academic venues, disclosure is likely required. This includes AI.generated portions of manuscripts, AI.created figures or visualizations, and AI.drafted summaries or abstracts. Step 2. Check whether any exemptions apply. The Act includes exemptions for certain uses, including AI systems used purely for research and development activities that are not placed on the market. However, research that gets published may not qualify for this exemption. Step 3. Implement appropriate disclosure. For most researchers, this means clearly stating in your publications what role AI played in content creation. This should be specific enough to meet transparency requirements, which AI tools, for what purposes, and what human oversight was applied. Step 4. Document your AI use process. Keep records of your prompts, the AI outputs, your editing and verification processes, and your disclosure statements. This documentation demonstrates good faith compliance if questions arise. Step 5. Stay updated on implementation guidance. The EU and member states are still developing detailed guidance on how these requirements apply in practice. Monitor updates relevant to your field. Let me address the most common questions researchers have about the EU AI Act. First question: does this apply to me if I am not in the EU? The answer is yes, it likely does. If you publish in European journals, collaborate with European institutions, or conduct research involving EU citizens, the Act may apply to you. It has extraterritorial provisions similar to GDPR, meaning it can reach beyond European borders. Second question: is using ChatGPT for grammar checking considered AI-generated content that requires disclosure? The Act focuses on content that is substantially generated by AI. Minor editing assistance like grammar checking or spell checking likely does not trigger disclosure requirements. However, if AI generates significant portions of your text, that does require disclosure. When in doubt, disclose anyway. Third question: what are the penalties for non-compliance? The Act establishes significant fines. For the most serious violations, penalties can reach up to 35 million euros or 7% of global annual turnover, whichever is higher. However, enforcement mechanisms are still being established, and researchers acting in good faith with reasonable disclosure practices are unlikely to face severe consequences. Fourth question: how does the AI Act interact with journal disclosure requirements? They complement each other well. Journal policies often require more detailed disclosure than the AI Act mandates. If you are already complying with major journal requirements from publishers like Nature, Elsevier, or Springer, you are likely exceeding the minimum requirements of the AI Act. Think of journal policies as the higher standard that encompasses regulatory requirements. Here's the impact of understanding and complying with AI regulations. When you understand the regulatory landscape, you can use AI tools confidently, knowing you're operating within legal boundaries. Compliance protects your research from future challenges. As AI regulations are enforced, past work that didn't comply could face scrutiny. Building good practices now protects your publication record. Understanding regulations positions you as a leader in your field. As your colleagues struggle to understand these requirements, your expertise becomes valuable. You can help your lab, department, and institution navigate the new landscape. Compliance demonstrates research integrity. Transparency requirements exist to build public trust in AI-assisted work. When you comply fully and transparently, you contribute to that trust, and staying informed helps you adapt as regulations evolve. The AI Act is the first major framework, but it won't be the last. Understanding how these regulations work prepares you for future developments in AI governance. Researchers who master this regulatory environment will thrive in the AI era. Let's summarize the key takeaways from this video. First, the EU AI Act is real and relevant to researchers. It's the world's first comprehensive AI regulation, and its transparency requirements likely apply to AI use in academic publishing. Second, Article 50 transparency obligations are the key provisions. AI-generated content that informs the public, which includes most published research, requires disclosure. Third, compliance aligns with existing best practices. If you're already following journal AI disclosure guidelines, you're likely meeting AI Act requirements. The key additions are documentation and awareness of regulatory obligations. Fourth, stay informed as implementation develops. The Act is being phased in over 2 years, and detailed guidance is still emerging. Monitor updates relevant to your field and institution. Make regulatory awareness part of your AI literacy as a researcher. Here's your takeaway to remember. The AI Act isn't a burden for researchers who use AI transparently. It's a codification of practices that ethical researchers should already be following. If you're disclosing your AI use clearly in publications, you're likely already compliant. If you're not, now is the time to start. The researchers who will struggle are those who've been hiding or minimizing their AI use. Transparency requirements make that approach increasingly risky. In the next video, we'll explore AI authorship and why AI can't be an author under current academic norms. If you found this valuable, subscribe and hit the notification bell so you don't miss it. Thank you for watching. This video covered just one concept from Impact or Invisible, Surviving the Data Age with AI. The full book includes comprehensive frameworks for AI-powered research, step-by-step protocols, copy-paste templates, and strategies for researchers at every career stage. Get your copy on Amazon today and transform your research workflow. Don't forget to subscribe for more videos in this series.